Thank you, Chair. Thank you, Mr Brereton. When I talk to people in my community, they approach me and tell me that they've gone from a sense of joy that a federal anti-corruption commission has been created and exists to now profound disappointment about how the NAC has operated since its inception. You've identified in your comments in the annual report that people support the creation of the NAC, that they support the concept of the commission, but many have approached me saying it hasn't delivered to its potential. Why do you think Australians feel this way?
Largely because corruption investigations take time, and it will take time for some of the investigations we're conducting to produce results and show the value of the work we are doing.
What would you say to those people that have expressed these views or feel this way? Just to be patient, I suppose? Is that what you're suggesting?
I would say that we are conducting 29 full investigations at the moment. I've already referred to the preliminary investigations. That some of those are complex and difficult, and that if they want to see results in terms of outcomes of investigations from the Commission, those will take time to produce results. But I think there's something also to be said, and that is, I think integrity is on the Commonwealth agenda, on the lips of departmental secretaries, on the agenda of every second meeting around Canberra at the moment. And I think we have a lot to do with that. I think our promotion of the cause and our engagement activities have had a great deal to do with elevating the importance of anti-corruption and integrity issues and the attention it is getting and the attention which officials all around the country are paying to it. And I think that's already a very significant outcome.
You mentioned in your opening statement, just as an aside, perhaps through you, Chair, or to some of your staff, Mr Brereton, if at all possible at future public hearings, if you could provide us with a written copy of your opening statement. I did try to take notes as you were reading it out, but I don't want to incorrectly quote you. But you did mention some of the prevention strategies, which you've just referred to. There are 125 presentations and engagements, 64 of something else. And I do note in your report in the forward that you have two main lines of operation, being deterring corruption through detection, investigation, exposure, and preventing corrupt conduct through education and engagement. I guess I'm struggling to understand where the exposure of corrupt conduct has been in your operations to date. How I'm giving you the opportunity to answer this. How are you exposing corrupt conduct?
Through the investigations that we are conducting, which will, when they come to light, expose corrupt conduct, through the prosecutions that are on foot at the moment as a result of the prior Ackley investigations and our Operation Pelican investigation, all of those involve the public exposure of corrupt conduct. When we publish our reports, that will expose corrupt conduct.
Have you considered the commencement of a public investigation yet?
We have, and we have a number of potential subjects for public inquiries under consideration. Frankly, we have got enough work, well, more than enough work coming in through the referrals at the moment that we have considered it important to deal with the bow wave of referrals and manage them before we turn our mind to a more generic public inquiry. But yes, we have and continue to turn our mind to a public inquiry.
How important do you think public inquiries are to undertake your function of exposing corrupt conduct?
Yep. I think they're an important part of the function.
Why is that?
Because they will provide a public airing of general corruption issues without descending to specific corruption issues involving individuals. The difficulty is drawing that line between specific issues which we can't do or make the subject of a public inquiry and a general inquiry into vulnerabilities and risks. But I think a general inquiry into vulnerabilities and risks is going to be very valuable in some areas.
So is there any reason that... So what's the reason for not, I guess, pulling that trigger just yet? Are you still undertaking investigations? Have you not concluded, not reached that threshold? I'm just trying to understand.
We are looking at the referrals that are coming in and having them examined by our strategic intelligence team to identify some thematic areas or some recurrent themes, if you like, that we think might be appropriate for a public inquiry. And as I say, we've got a couple of, I think there's 3 or 4 areas in which we're now getting enough of those recurrent themes to suggest that that might be appropriate.
Are you able to share any of those themes?
Broadly, yes. So one involves corruption risks and vulnerabilities associated with the National Disability Insurance Scheme. Another involves corruption risks and vulnerabilities associated with the employment of contractors, particularly contractors in labour hire firms that may then be engaged in effectively hiring their own contractors and expanding the influence that they have in the relevant agency. And the third is corruption risks associated with grant schemes. So they're the 3 particular ones we're looking at.
Can I just add to that, because I have a special interest in corruption prevention and education. One of the things the Commissioner's talking about with trying to get through the investigations is we're starting to see these things that he's raised as trends and coming up in a lot of those, not just the 4,000 referrals, but things that are actually getting to the preliminary and full investigation stage. What we're waiting for is the outcomes of those investigations so that we can actually use them as real-time case studies and show, particularly because we haven't had a Commonwealth Anti-Corruption Commission before, and we've been using examples from state and territory anti-corruption agencies, that we want to be able to use our real examples and recent investigations to actually show where the risks and vulnerabilities are. So it's just that patience of we're trying to get some of those outcomes of those investigations so that we can actually bring them, the findings out through those public inquiries.
And finding these patterns and themes, using your words, is that to link it to the definition of systemic corruption that exists in the legislation? Is that what you're trying to do there, or you're just making sure you've got...
It's not necessarily tied to systemic, but if we want to have a public inquiry, I think we want to do that into something that is going to have more than an incidental impact on one thing, and the trigger, or not necessarily the trigger, but the sign for a public inquiry to me at the moment is if we see an area in which there appear to be recurrent issues or problems, that might well be an appropriate target for a public inquiry.
So that we can identify the vulnerabilities and then raise the capacity in the general public service to look for those vulnerabilities and target harden them. But it's having that real-time data to use that.
Look, I understand public inquiries are rare. In my home state of New South Wales, I think this year the ICAC's only had 2 public inquiries, the year before 4. So it may not be a like-for-like comparison, but I'm just...
There is an important distinction. In New South Wales, a public inquiry is what we would call a public hearing in a corruption investigation, which is quite different from our concept of a public inquiry. So in New South Wales, if we were to hold public hearings in a corruption investigation, that would be equivalent to a public inquiry in New South Wales. But for us, the exceptional circumstances test applies to that. Our public inquiry is quite a different creature. It's more like a commission of inquiry into an issue than a public hearing of a corruption investigation.
In the 35 years of operations of the New South Wales ICAC, they've only done 3 public inquiries as we are describing them.
Right, okay.
2 on lobbyists and 1 on pork barrelling.
Right.
Everything else has been the equivalent of what we would call public hearings.
Okay.
We'll need to rotate the call, but I can come back to you.
Okay, thank you. In the forward, Mr. Brereton, you mentioned as part of 221 cases which passed triage and no further action were taken, some of them had no further action because it would not add value in the public interest, and that reason was one of 3 reasons that you put in your opening statement. I guess I just want to try and understand what you mean by would not add value in the public interest, because I guess my personal interpretation of that is that, look, in your investigations, some corrupt conduct could have been identified, but it didn't meet, according to the decision made by the Commission, it didn't meet that public interest test. Could you explain how you define how something would add value to the public interest, even though corrupt conduct might exist?
I guess that brings me back somewhat to my answer to Dr. Haynes a little earlier. So, if something has already been investigated by another agency, us investigating it is unlikely to add value in the public interest. If something is already under investigation by another agency, even though it hasn't proceeded to completion, it's unlikely that we're going to add value if they've got the capability to investigate it. And another example that I'll touch on is there was one case that I can recall of misuse of information which could probably have been proved by a public official who was a victim of domestic violence and who was accessing official information for the purpose of tracking her abuser. And we didn't think it would add value in the public interest to open a corruption investigation in those circumstances, even though it fell within the definition of misuse of information.
Okay. That's all the questions I had in regards to that. Thank you, Chair.